Hello everyone, welcome to my presentation on search and seizure. Just an overview of search and seizure. Search and seizure is a procedure performed by cops or any authority figure that suspects that a crime has been committed. On such suspicions, they then search the person's property or belongings and take anything they feel is connected to a certain crime. In this case, in the education system, law enforcement officials have to have probable cause in order to search a student. They also have to obtain a search warrant before searching a student's book bag, locker, car, etc. I'm going to be talking about a few court cases. The first one is New Jersey versus a student who goes by TLO. She is a high school student, and school officials suspected that she had cigarettes. They found the cigarettes, but they also found a small amount of marijuana and a list containing names of students who owed her money. She was charged with possession of marijuana, but she moved to suppress evidence discovered in the search. The court denied her motion, but they then later, the New Jersey Supreme Court reversed her motion based on the Fourth Amendment that protected her rights, and she was eventually set free and does not have that charge on her file. The next one I'm going to talk about is Thompson versus Carthage School District. Upheld a search of all students grades 6 through 12 because of reports that a student had a gun. Now, since it was such a serious and dangerous occurrence, they believed it was minimally intrusive, and it was justified in light of the need to uncover, obviously, a dangerous weapon, a kid concealing a gun. So on those standards, they believed that it was minimally intrusive. The next one is Desroches, ex rel Desroches versus Caprio. This is completely opposite end of the spectrum. It was a search of all students for an allegedly stolen pair of sneakers. Obviously, it was not upheld in court because basically, if it's a very serious crime, then it's going to be very minimally intrusive. But if it's a very obviously not very serious crime like a pair of sneakers, it's just not going to upheld, or it's not going to hold up in court. So this isn't a court case. This is about school property. This is about determining school property versus personal property. In determining whether a particular search is reasonable, the courts have distinguished between school property and personal property. Obviously, school property is something that belongs to the school, so that's going to be lockers and stuff like that. But personal property is your book bag, your wallet, your purse, basically anything that's going to be on you when you're in school. And searches of student personal possessions like vehicles require that there be an individual suspicion that a violation of law or school policy has occurred. So basically, if you want to search a student's car, you're going to have to get an individual suspicion of, you have to basically narrow it down to one student. And you obviously still have to get a search warrant, but then you can go into things like personal property, like cars, stuff like that, where you think you'll find evidence of crime. The next court case I'm going to be talking about is United States versus Place. The Supreme Court says that the use of dogs to sniff objects is not a search because it's not a violation of someone's reasonable expectation of privacy. This is very true because the dogs don't actually go into your lockers, your purses, and all that stuff. They just sniff around. They just sniff the air around the objects to find anything like marijuana or any type of drug that gives off a strong odor. Strip searches, because of their intrusive nature, have been prohibited by law in the following states: California, Iowa, New Jersey, Oregon, Washington, and Wisconsin. They're carefully scrutinized by all areas and most often disallowed by courts. So they are prohibited by law in those states, but they are carefully scrutinized by all areas, even Ohio, and obviously are going to be disallowed by the courts because of their very intrusive nature. So the last court case I'm going to be talking about is Vernonia School District versus Acton. Supreme Court found a school district's policy requiring student athletes to submit a random pee test reasonable under the Fourth Amendment. They agreed with the district's contention that the police was justified based on its interest in keeping the athletes free from injury and deterring drug use. So basically, they agreed because it was on good terms, basically just keeping athletes safe, because obviously a lot of athletes use steroids nowadays, and basically just deterring drug use in general. And obviously, it's no more intrusive than adjusting in a locker room because when you take a P test, you are in an enclosed area with no one around you, and you just basically just pee into a cup. So no one's watching you. It's not very intrusive. It's just something they have to do to obviously keep the athletes free from injury and deter drug use. And that is my presentation. So thank you for listening.